definitely have you all in the coolest place in this building, I may say. I've been looking forward to coming back into court, which is not often the way, but it certainly is today. Yes,
my Lord, before the short adjournment, I was dealing with my sixth proposition, which was the words, the meaning of the words for any reason in the context of the act of not having given further notice. I want to move to the stated purpose of those words as advanced by Providence. Providence submits, as we understand it, that the stated purpose of the introductory words to clause 8.9.4, if the contractor for any reason does not give further notice, is to clarify that the clause extends to cases where no right had arisen to terminate under clause 8.9.3 because the specified default had ended. In our submission, that is wrong for two reasons. First, the words are at best unnecessary because the clause without those introductory words would have made that clear. So at best they're unnecessary in our submission. But at worst, the introduction of those words in fact are consistent with our interpretation of the clause, which in effect means that the draftsman is to be taken to have purported to expressly clarify and deal with the situation, but in fact doesn't refer to the situation at all, at least not expressly in this clause, and in fact introduces words which are at best unnecessary and worst, on Providence's case, consistent with our construction. Can I move to the question of the employer termination provisions? Clause
just before you do, if on your interpretation, on the judge's interpretation, if you have to have an accrued right under 893 before 894 is triggered, then there's a condition that needs to be fulfilled. I mean, Mr. Channels called it a condition precedent. That may not quite be right, but a condition that needs to be fulfilled. Would you accept that usually in contracts, certainly JCT contracts, but generally in a commercial contract, you'd expect to see the condition, the need to fulfill a precondition, to be set out rather more clearly than this is?
Well, dealing with the question of condition first, and then dealing specifically with your Lordship's question, we would take issue with the description of it as a condition precedent.
Without it, you don't get to 894.
We accept, as a matter of fact, in terms of the interpretation of clause 8.9.3, that a right under 8.9.3 must have accrued before one can terminate for a repeated specified default. We submit that it is clearly stated on our interpretation of the clause, because when the clauses, then the sub-clauses are construed in context by reference to each other, then in our submission the position is clearly stated.
Okay, well if that has to be the answer, because if it's not clear, then that's going to count against it being a condition, because a condition should be clear. If you're saying you can't do something until you've done something else, you say, well, it's clear that that's how it works. If that was not right, if the court took a different view, then it becomes problematic, doesn't it? Because if the court considered that at best it was muddly how it was expressed, then it would be a condition that would be blushing into the spotlight.
Well, Lord, court will interpret the clause as it ought to be interpreted.
And as is apparent, I'm sure, from this morning's questions, we have no idea ultimately how we're going to do that. So it's all, as it were, up for grabs. I'm just exploring this particular point, because this is, speaking entirely for myself, this is the particular point that I think may arise, and I just want to get it clear what the answers are.
Well, describing it as a condition, whilst I would accept the ability to exercise a right under 8.9.4 only arises in the event of certain circumstances arising under 8.9.3, and one might describe that as conditional, I would not accept that it's a condition precedent, and
Understand.
would not accept on the authorities that it needs to be unequivocally clear. But the court will come to its own interpretation of the clause, and in our submission, for all the reasons that we've set out, the clause is unambiguous when construed in context.
Okay. So you were then moving on to 894, were you? Sorry,
8.4, my lord. Yes, dealing with the employer termination provisions, which
yeah.
So just before you do that, do you place any reliance on the word "the" as opposed to "a", so that what it is concerned with, as something which hasn't happened, is the giving of the further notice referred to in clause 8.9.3? Do you say that the further notice which refers to in 8.9.3 is ex hypothesi a notice which one is entitled to give under clause 8.9.3?
My lord, that's in essence our case, where you construe 8.9.4 in context and specifically by express reference back to 8.9.3.
I understand that, but so far the judge has been focusing on the words does not give, as have you, and we've been looking at the words for any reason, but I hadn't yet detected particular reliance on you on the word "the", but obviously it's consistent with your submission. I was just wondering whether you place any reliance on a difference between "the" and "a".
Well, we submit in essence that the introductory words to 8.9.4 must be an express reference back to 8.9.3, and therefore is expressly referring to the situation where the contractor had a right to serve a termination notice in the circumstances of that clause, but the contractor has not done so for any reason.
But it's the intermediate steps. It's quite easy to accept that under 8.9.3, the right to give a notice only arises, and therefore such a notice only exists after the specified time. And we can see 8.9.4, as my lord says, that we're interested in under 8.9.4 is the further notice referred to in clause 893. And I can readily be predisposed towards an argument which says context is everything, and if you look at that. But I think what I find difficult is nailing down the link which underpins why you say it's obvious, because it's all very well saying it's obvious, and it may be that in the end we say it's obvious, but it would be much nicer to be able to rationalise exactly why the further notice.
If I may put it in this way, I mean, I've asked myself that question, and instinctively, when you first read that clause in my submission, you in 8.9.4, you interpret it in the way that Hexagon interprets it, and it's pinning down why instinctively you reach that conclusion. A central reason why one reaches that conclusion is because of the words "does not give." And when those words are construed in context, it drives one to a conclusion that it is referring to a discretionary right under 8.9.3, as opposed to a situation where one cannot have given the notice because no right arises in the first instance.
But if you load all the argument onto those words, does not give, you are having to treat those, first of all, as meaning could but does not give, or fails to give. If it said either of those, it would express what you say it means. But that is clearly a gloss on the language used, rather than simply does not, which refers to something not happening.
Well, that's my learned friend's.
And that's your learned friend's case.
That's my learned friend.
And speaking entirely for myself, I think your argument has to build on that a little by reference to the context and the rest of the provision. I mean, not least because in 8.4 the very same expression is used to mean what Mr. General says it means. But it doesn't mean you're not right. I'm just, at the moment, if you put all the weight on those three words alone, I'm having difficulty, perhaps like my lord, in seeing how you jump from context to what those words mean.
Well, my lord, if those words are construed in isolation, I accept that in isolation they're capable of meaning or extending to what my learned friend submits they're capable of meaning. But context is everything, and when one construes those words in the proper context, and I'll come to the employer termination provisions in a moment. But those words in context, I'm repeating myself.
Well, I think the point I'm putting to you is, in the context, they're only capable of meaning what you say they mean if you gloss them to mean could but does not give or fails to give. You actually have to gloss them rather than take them on their face to get the context, to make them mean what you say they mean. I think that's what I'm just trying to articulate as the point I see against you.
I'm not sure I would accept, my lord, in most.
No, well, I may not be right. I'd just like to know why I'm wrong.
One has to gloss those words. One doesn't need to gloss them because one construes them in context.
Well, I think that's where my lord's "the" comes in.
I think that aids.
8.9.3 doesn't use the word "give." I don't think. By further notice.
By a further notice.
Yeah. So you can't. There's a link that isn't there. If it said "give," you could. It might be an additional link. But your argument has to be that giving the further notice referred to in 893 means giving a notice which they're entitled to give. And it's how you make that link that certainly I'm finding troublesome, although I am always disposed to spend a lot of time looking at context. And it may be that, I think, I'm slightly thinking as I go along, but the word "the" could be critical because you're talking about giving, the question of giving simply doesn't arise unless it's an 8.9.3 notice that they're entitled to give.
Quite. I mean, the words "the contractor" in 8.9.4, the contractor, is clearly a reference back to the contractor as identified in the second line of 8.9.3.
Yeah, that's easy.
So one is identifying,
unless you've assigned
in 8.9.4 the circumstance which is identified in the first two lines of 8.9.3 but hasn't happened.
Surely the contractor just means the contractor.
But the words "the contractor" is referring to the contractor as identified in 8.9.3.
Yeah, that's the whole way through the contract. I think that doesn't take matters any further.
Yes, well, I'm not sure. I mean, obviously it is because
it
8.9.3 also refers to the contractor. But
But it's serving, in our submission, it's serving to underline that one is talking about a situation that has not arisen under 8.9.3 but could have done. Because the contractor can only give a notice under 8.9.3 in the event that the period has elapsed. I know I'm repeating myself about context, but and repeating my submission about the structure of the clause itself. But that's why I started my submissions by emphasising the interrelationship between the subclauses, because it's the interrelationship, it's how the clause operates as a whole that provides the context. My Lords, can I move to the employer termination provision, which is found at page 88 of the core manual, tab 11. We respectfully agree with the learned judge, paragraph 22 of his judgment, when he indicated that the court should be cautious in placing too much emphasis upon a different clause in a contract when interpreting clause 8.9. But we accept, of course, that it is relevant context and the contract must be construed as a whole. Providence submits that clause 8.4.3 falls to be construed in precisely the same way as clause 8.9.4, and that the words "whether as a result of the ending of a specified default" mean, or at least include, the ending of a specified default before a right of termination has arisen. So that on Providence's case, the draftsman has considered it necessary to make express in clause 8.4 what he's been taken to be content to leave implicit within, on Providence's case, within clause 8.9. I'll come back to that submission in a moment. But first, Hexagon acknowledges that there is an ambiguity in the employer termination provision. Providence presumably accepts that those words would refer at least to a situation where the right of termination has arisen but not been exercised as a result of the ending of a specified default. That's its case. We submit it is not necessary to read those words as also extending to the case where no right of termination has arisen because the specified default has ended. And if that is right, then there is no material difference between the two clauses.
Sorry. So you read it as meaning, or at least capable of meaning, that it's restricted to cases where the specified default has ended after
the right of
termination has arisen.
My Lord, yes. And if that is the correct interpretation of the clause, then there is no material difference between the two clauses. But if that
you would accept that there's no such restriction in the words, because it's talking about the ending of specified default. It doesn't say after, just the ending of any specified default. So that could be either before or after the right to termination accrued under 842.
We acknowledge that it doesn't say expressly. That's why I describe it as an ambiguity.
How does an ambiguous 8.4 help us with what you say is an unambiguous 8.9?
Well, what I'm going to do is focus my submissions on the basis that Providence's interpretation of clause 8.4 is correct. But I want to acknowledge that there is an ambiguity in the clause.
So if this was a flow chart, your first point would be, well, it doesn't say what they say it says, and therefore any point they make on it doesn't run. And then if you're wrong about that, you're about to make your other submissions.
Quite.
Okay, understand that?
If Providence's interpretation of clause 8.4 is correct, our primary submission is that that is not a consequence of the words does not give, but is a consequence of the additional words that are omitted from clause 8.9.
I understand that submission, but it still means giving the words does not give a different meaning in this clause to in 8.9, doesn't it?
Well, it does, quite, but it's the conjunction between does not give and the ending of any specified default which gives the words a different meaning. And just to unpick that a little, on Providence's case, the draftsman should be taken to have intended the two subclauses to be the mirror of one another. And in our submission, it's significant that the draftsman should have used different language, and in particular used the words critical to Providence's case in clause 8.4.3, but omitted those words from clause 8.9.4.
Replace them with the words for any reason, which I wouldn't have thought were narrower.
Well, you would expect, if the draftsman was seeking to mirror the two clauses, he would have used the same terminology.
I agree.
Could have, in fact.
That might be a starting point to say, therefore, the language that's been used must be narrower in the clause we're construing. But the equivalent language plainly isn't narrower.
Well,
is it?
Well, my learned friend's case is not that the clauses should be construed differently from one another. In his case is that the clauses mean the same thing.
I agree, and I understand your point conceptually, that if they meant the same thing, they would have used different language. But they use the same language in relation to does not give, and the critical difference, you say, is in what's in the brackets.
Right.
So we get to that stage, but then the point is, what's in the brackets is, if anything, wider in 8.9 than it is in 8.43, which is not a reason, therefore, for construing 8.9 more narrowly than 8.43.
Well, the words for any reason in 8.9 are not to be construed in their widest sense, because they're to be construed in context. And that gives the meaning to the words does not give in the context of which they're used in clause 8.9.3. If we start from my learned friend's premise that what the draftsman is seeking to do by these words in both clauses is to deal with the apparent ambiguity or the risk of an ambiguity of dealing with a case where a right has not arisen under 8.9.3, but nevertheless retaining a right to terminate under clause 8.9.4. That's the thrust of my learned friend's submission for the introduction of the words in clause 8.9. It's the same. He makes the same point in essence, or should be taken to make the same point in relation to clause 8.4. That the words in parenthesis are designed to clarify and confirm that a right to exercise termination under 8.4.3 can be exercised notwithstanding that a prior right had not arisen. And in our submission, it is significant, it is striking, that those critical words are omitted from clause 8.9, but are introduced into clause 8.4.
But it's only significant if it were arguable that the words in 8.9 are narrower than the words in 8.4, I think. And they're not.
Well,
So I think.
Well, my lord, in context,
I think I'm missing something here.
in context, they are to be construed more narrowly.
And when you say context, what we're looking for is some respect in which the context in 8.4 is in a relevant sense different from the context in 8.9. Now, again, I'd just like you to help me a little bit on that, because I quite understand that we have different events, some different events, some equivalent. But in terms of the structure of the notices, what's the difference?
They're materially, I accept they're materially the same.
The same.
Although the employer, I'll deal with this in more detail when I look at the commercial implications. But the contractor defaults are more closely analogous with material breaches that go to the root of the contract. They identify the failure of the contractor to comply with instructions, unlawful suspension, failure to comply with CDM, where the focus of the employer termination provisions, or the contractor termination provisions, I'm sorry, are late payment.
Okay. Can I just pick you up on that? I'm sorry to be difficult, because whatever the relevant termination clauses mean, 8.4.3 or 8.9.4, they must mean the same for each of the triggering defaults, original triggering defaults. They can't change their meaning depending on whether it's payment, assignment, or the CDM regulations. Would you accept that?
I would accept that.
So we have in 8.4 and 8.9 failure to comply with clause 3.16, the RDM regulations. And although what the employer does for health and safety and what the contractor does for health and safety aren't going to mirror each other exactly, I would have thought, but tell me if I'm wrong, because I'm no expert on this area, that the sort of things that they could do in breach of the regulations might be seen very much as broadly equivalent in terms of seriousness. They might be serious, they might be trivial on both sides. Would that be right?
Well, I think that the contractor breaches of CDM may give rise to fines on the employer. I'm not sure it works the other way around.
Well, the employer has duties, presumably, under the regulations.
But depending on their role, both have duties under the CDM regulations.
Right. So that perhaps I'm now straying on to the asymmetry point, but is there really an asymmetry between the two situations if they can be triggered by breaches of really equivalent regulations in relation to health and safety?
I'm sorry. I accept that there's overlap within the default, the types of default under each provision. Broadly as a package, put it this way, broadly as a package, the contractor defaults are more closely analogous to material breaches of contract. That's my submission. And that is one explanation as to why under 8.4.3 a specified default may not have, a right of prior termination may not have arisen in order to allow an employer to terminate for a repeated breach, because the underlying breaches are more significant.
But I think the argument that you have to face on that is that the termination provisions don't apply to a package. They apply to each individual element of it. So it doesn't help very much to just to characterise the package as a whole and say most are of one kind, even if some are not material breaches.
Well, I accept that, as I've said, I accept that there's an overlap. My description of the package, as I put it, provides some justification. To the difference in wording and meaning of 8.4.3.
Thank you.
In our submission, the use of different language in the two clauses is a surprising inconsistency in any professionally drafted contract, but it's all the more so in a standard form contract. And Providence makes the point, and we accept it, in its skeleton, paragraph 19, page 31 of the core bundle. Where it says that Providence also places some emphasis upon the fact that the appeal concerns the wording of a JCT standard form in wide use, such that the focus should be on the words used which should be taken to have been selected after considerable thought and with the benefit of input and a continuing review of users of standard forms. We accept that as a proposition, which makes the inconsistent language all the more striking and significant in our submission.
Well, not necessarily significant. Just maybe bad drafting.
Well, if you start from the premise that we'll look at the archaeology of the forms when I take your lordships to that, where the previous edition of the form, the 1998 form, the language clearly mirrored each other. A learned friend's case, and we don't accept it, but a learned friend's case is that the change in language was introduced to summarise effectively and to abbreviate the two termination provisions. In our submission, it is significant that the draftsman, intending to make those abbreviations, where the previous forms mirrored each other, wouldn't use precisely the same abbreviation within the same clause. And my Lord, Melanford has taken you to some of the authorities on in his submission on why doesn't the form say that? Can I just emphasise two or 3 points? The first is Lewison on interpretation of contracts.
So just so for my notes, which are we in now? You've dealt with the textual analysis, which was your first heading, or are you still in that?
I'm still in the textual analysis.
Okay. So fine, yeah.
I'm dealing with a different language used in clause in clause 8.4.
Okay.
So dealing with the excerpt from Lewison, page 81 of the authorities bundle. And I'm not sure there's very much between my learned friend and I in relation to this, but it's under the heading why not say it, and it's at the very bottom of page 81, referring to the dissenting judgment of Lord Neuberger in Sigma Finance, where he said, "I do not think it's normally convincing to argue that if the parties had meant a phrase to have a particular effect, they would have made the point in different or clearer terms. That is a game that all parties can normally play on issues of interpretation, save in relatively rare circumstances, e.g. where the document concerned contains a provision elsewhere in different words, which has the effect contended for by one of the parties, it does not take matters further. And we submit that this is one of those rare circumstances where the words that my learned friend seeks to imply into clause 8.9, which is vital to his interpretation, the ending of a specified default, are used in the employer termination provisions in clause 8.4 but omitted from clause 8.9. So in answer to the rhetorical question, why not say it, he offers no explanation.
So what words do you say he's implying into 8.9?
There's been an ending of a specified default.
What been an ending? I didn't hear.
The ending of a specified default.
But you don't say that that's not covered by for any reason. Leaving aside your context point, as a matter of English, as a matter of the words, for any reason must include that specific reason.
Well, you say it, leaving aside the context.
Yeah.
In my respect.
Well, we are leaving aside the context for this purpose because this is, you're just saying different words. You're relying on the fact that there are different words.
Yeah.
But if in fact that difference is not a difference in effect, then it doesn't take the matter further.
Well, in our submission, it is striking and significant that for any reason is not used in the same way as the same device as it's used in clause 8.9. Learned friend's position being, as I understand it, that those words for any reason are introduced to resolve a potential ambiguity. So you have a situation on Providence's case where the draftsman is seeking to resolve a potential ambiguity. On his case, uses the word for any reason in clause 8.9, which we say construed in context means something very different. But for reasons which they do not explain, in the same clause, uses the words expressly, or deals with the ambiguity expressly, and he offers no explanation for that. And in our submission, that gives rise to an inference. The clauses are not intended to have the same effect. Just briefly for your note, whilst I'm on the authorities, the reasoning of Lord Justice Christopher Clark in FCC and Black Diamond supports the same proposition as as stated in Lewison. It's at page tab 6, page 92, at paragraphs B to C.
Paragraphs?
Paragraphs B to C, page 92. Actually, internal paragraph 29. The facts are not material in my submission. First, if the draftsman had intended that any assignment of an arrangement or composition made or proposed with all the creditors of the issuer but your subsidiary would amount to an event of default, he could easily have said so by repeating the words all of its debts, which he had used 2 lines before. I recognise that this is an argument that can often be invoked in cases where the meaning is unclear, and sometimes by each side, but in circumstances where it is said that the draftsman meant all when he did not say all, it appears to be opposite. And in our submission, that's the position here. And then a friend says, well, you could just imply within the words for any reason, which we submit is taking the words out of context. But the same draftsman expressly states and resolves the ambiguity in clause 8.4. And in our submission, that's striking and significant. Because the way to resolve the ambiguity, alleged ambiguity in clause 8.9, was to introduce the very words that the draftsman used in 8.4. And in our submission, it drives the inference, or creates the inference, that the clauses were intended to mean different things.
But, I'm sorry, I'm being really stupid about this, but it doesn't, the words in 8.4.3 don't cure the ambiguity, because they leave open the question of whether they cover a situation where the specified default ends before or not before the right to give the notice under 8.4.2.
Well, that's my ambiguity point.
That's your ambiguity point, but
That's
in tension. That's in tension with your suggestion that by using a different expression, they intended a different effect.
Well, it's on my learned friend's interpretation of clause 8.4, there is no ambiguity. It means
yes.
The clause means what it says.
Yes. And that's what sets you up for saying, well, they can't have intended to use two different formulations to mean two different things. But on your primary case, they're not doing that.
It just means that the final check of the draft didn't pick up the difference.
Well, when one looks at the proposition in relation to standard forms, that the court is to assume that the wording has been carefully considered, more so than in any well-drafted professionally drafted commercial contract. The authorities point to the fact that what the court should approach the construction on the basis that the wording has been carefully considered by the draftsman. That is in our submission, that is a surprising error by the draft person.
We have to, I completely understand that submission. We have to temper that with the knowledge that when the JCT person was preparing the guide to the contract, they dealt with the two parties as if the submissions were symmetrical. Sorry, as if the provisions were symmetrical. So they didn't think there was a difference. For what it's, I quite accept that's for what it's worth, which may not mean very much, but I don't think we need to get too hung up about the question of the standard form and whether it's shock horror news that JCT draftsmen might not quite get it right all the time.
I know nothing about the JCT process, but I've spent my life in commercial cases with iterations of charter parties, for example, which have gone through endless consultation and drafting and have just thrown endless ambiguities and infelicities.
Well,
they're standard forms. It's not a very strong presumption, I think, is what I'm saying.
Why this is significant is because of my learned friend's case, that the wording, for any reason, is introduced to deal with an ambiguity that the draftsperson recognises.
I understand that point. Then conversely, if contrary to your primary case, 8.4 is different, then it is superfluous, isn't it? It could just have said if the employer repeatedly breaches.
On my ambiguity point?
No, not on your ambiguity point. On Providence's point.
On Providence's point.
That it has the effect which they contend 8.9 has, which you say, in relation to 8.9, makes 8.9 unnecessary. It would equally make 8.4 unnecessary, wouldn't it?
It would, yes. The difference in wording as we submit is significant, and that's not lost on Providence. They describe it as a modest elaboration. The difference in wording, in my submission, for all the reasons I've given, it's more significant. It's more significant than that.
Or it may be completely insignificant. That'll be a matter for us. Yeah. Okay. Well, I think that's enough about clause 8.4.
Can I deal briefly with asymmetry? Asymmetry in commercial contracts is not unusual. Like any commercial contract, construction contracts distribute risk differently. I've already dealt, in answer to my Lord's question, the fact that I want to make some observations to support my submission that asymmetry in this case is unsurprising. The grounds for termination are different. I've already addressed my Lord in relation to No amendments. Second, no amendments.
Of course they're different because the obligations are different. This is a classic case. Reg and Dill against late payment. I mean, let's get to the meat at this point.
No amendments were made to the standard form wording of 8.4.2 and 8.4.3. That's the employer termination provisions.
No, because all the amendments were done by the employer who was giving himself more time to make late payments.
Except it's a debenture document.
These aren't great points, Mr. Lewis.
Well, if I may just deal briefly with the, I'm going to deal briefly with the asymmetry points. The employer has a right to terminate at will, which was introduced by the amendments. And given the bespoke amendments, it would be surprising if the parties should be taken to have intended symmetry. Can I move to my third topic of commercial consequences?
Yeah.
First, dealing with Providence's suggested justification for its interpretation. Providence submits that a contractual right to immediate termination on the repetition of a default is necessary to address, in particular, the consequences to a contractor's cash flow and to that of its supply chain of repeated late payment, and that other remedies are inadequate, other contractual remedies are inadequate to address that fundamental concern. I'll deal with the purported justification first and then consider in our submission, surprising consequences of Providence interpretation. First, it's not by accident in our submission that Providence makes its points against a background painted by it of a highly cynical employer who, within each payment cycle, intentionally pays at the last moment to buy the maximum amount of time to pay and avoid termination. Now, we accept, of course, that that may arise, but it is not a typical scenario, and so the mischief which is said to justify Providence's interpretation is not one naturally grounded in reality. A related point is that the emphasis on the prejudice of the contractor being kept from its money for 28 days is a consequence or a function of the bespoke amendment extending the standard period of 14 days to 28 days.
Well, is there any significance in that? Surely these clauses must mean the same in the unamended form as they do if you amend 14 to 28. That can't affect what these mean, can it?
No, but it's dealing with my learned friend emphasises the lack of commerciality or the importance of an immediate right to termination because of the contractor being kept out of its money potentially for a period of 28 days. My only point in relation to that is under the standard form.
It's only 14.
But most fundamentally in our submission, to suggest that a right to immediate termination on repetition is justified because it is the only remedy that alleviates the mischief associated with late payment is surprising and is to be rejected in our submission for the following reasons. First, termination to alleviate cash flow difficulties or difficulties with the contractor's supply chain is in many cases a non sequitur. Termination is obviously the most serious of acts, and it has serious consequences for both parties. Third, and significantly in our submission, termination under this contract does not give rise to the swift release of payment to the contractor. In fact, in reality, it has the result of significantly delaying any further payment that might be due to the contractor. And one can see that from clause 8.12, which deals with the consequences of termination. which is in the supplemental bundle at page 86.
But what's the significance of that? I mean, fine, they don't get a cash bonus of 500,000 on termination, but they reduce their overheads. They come out of the contract, and they just have to make the calculation when deciding whether to terminate, whether it's going to be beneficial or not.
They have to make the commercial decision, of course. My own friend's point is that termination is really the only remedy in this contract.
I don't think he's saying that. It's the nuclear final option.
And in our submission on the terms of this contract, it doesn't release payment swiftly at all. In fact, what it does in this contract
Nobody ever terminated a construction contract to get money quickly. You do it because you can't manage any longer. Or you feel that commercially you can't manage any longer.
Or the contract is unprofitable and you want to extricate yourself.
Well, now that's the cynical bit the other way. We just told us to abandon any thought of a cynical employer, so we should abandon any thought of a cynical contractor.
It was just a response to your lordship point, which is that the only reason...
I'm entirely neutral. Unlike Mr Duncan Wallace, I'm not on one side or the other. Contractual employers, equally great as far as I'm concerned.
I'm just questioning the basis for these submissions, where you assert termination to alleviate cash flow or supply difficulties is not always beneficial. No, but as my lord has said, it's there for whatever reason, or whatever the words are, for whatever reason, you can't keep going under the contract. And that's what it's there for.
Well, it's there to allow termination in the event of repeated default under 8.9.4, or for a specified default that extends beyond 28 days.
Can I just raise another possibility? This may be completely off beam, which is that the delay in payment may be greater or lesser and may occur, on your case, on a number of occasions, but the cash flow objective may be achieved by a deterrent, as opposed to whatever the particular consequences are of any particular breach, so that the commercial rationale may be, okay, it can sometimes occur if, it has happened twice, but it can sometimes happen if you're only slightly late twice, where the cash flow consequences are not very great. But even in those circumstances, it might be said, that's one end of the scale, it may be the other end of the scale, and the whole purpose is an incentive for the lifeblood to be provided when it ought to be provided.
My lord, three points in response to that. The first is that the right of suspension provides that incentive, and it provides that right upon 7 days' notice. So the contractor has and continues to have the threat of suspension. And my own friend says, well, suspension is impractical, but in my submission, the effect of a contractor suspending its works causes very significant delay and disruption to projects, which often in itself provides an incentive, one is looking at incentive, to the employer paying on time.
Well, that's a disruption for the contractor as well as for the employer, so that's not necessarily an attractive option from the contractor's point of view, is it?
Well, if it's a lawful suspension, the contractor recovers its costs or associated with that suspension under the contract. So the contractor is compensated. Its immediate cash flow difficulties are alleviated. But looking at the incentive, the potential disruption to the project is very significant, and that provides an incentive of in itself in our submission. The second point is that Parliament, when it introduced the Housing Grants Act, did not consider it necessary to create an immediate right of termination in order to provide an incentive. And given the central tenet of the Housing Grants Act was to ensure that employers paid on time, one of the central purposes of the Housing Grants Act was to ensure that employers paid on time and the parties could identify the sums due and provided for default provisions in the event of failure to serve a notice or payment. It is, in our submission, of note that Parliament didn't consider it was necessary to go as far as providing a statutory right of immediate termination in the event of successive default. And we do say, as we said below, that there are a number of mechanisms within this contract which provides the contractor with sufficient remedies for a late payment. The introduction of the mandatory mechanism for payments within the course of the contract is introduced by the Housing Grants Act. The right to refer disputes to adjudication. My learned friend rejects that as something that is attractive or useful, which is, in our submission, a surprising submission in circumstances where adjudication was considered central by Parliament to deal with a situation of late or non-payment. And as I've said, a right of suspension. And in any event, on either interpretation before the court, Clause 8.9.4 goes beyond the statutory default provisions and provides the contractor with a powerful additional remedy. On our interpretation, the contractor has a powerful additional remedy in the event that a right of termination has arisen but the notice has not been exercised. In those circumstances, to coin my law's phrase, the yellow card, or my learned friend's phrase, the yellow card is shown at that point, and for reasons that I'll come on to, that has a greater commercial justification than an immediate right of termination where no prior right has arisen.
Well, his interpretation involves one yellow card, yours involves two.
Or 10, or 15. You pay on day 27, you're allowed as many yellow cards as you like before you get sent off.
But you don't get yellow carded.
Yes.
Yellow card is, as I understand the submission, it's a formal step, namely the serving of a 893 notice, which means if you do it again, 2 yellow cards and you're off. So it's not the 27th.
Yes,
I know you're distinguished.
No, you're quite right. It's 29 days. Whether you've got to have gone beyond your 28 days in order to get a yellow card,
Yeah.
whether or not there's then a.
Well, it's
There's
on
no
this.
notice.
If you go beyond the 20, I'm sorry, if you go beyond the 28 days under 8.9.3, there's no yellow card. You've had your yellow card, you get served can get served a red card.
Yes, but if you don't, it's on your case, that it's only then, and when you've been exposed to a yellow card that you've been given, as it were, that you can go straight to a red card, whereas on the repeated breach.
Yeah.
So I think my law's right in that sense to say it's the expiry of the 28 days which is treated as the yellow card on your case.
Yes. And in our submission, that has greater commercial justification. Our interpretation has greater commercial justification than Providence's.
Because it's more serious.
Quite. I mean, that's the point.
That's it.
Yeah. I mean,
It's 29 days rather than 0 to 28 days. Fine.
Well, it's the fact that the employer has not remedied the default within the permitted period, and a right of termination has arisen, and the contractor indulges the employer in those circumstances. That's why it is easier to justify commercially the fact that in the instance of a repeated breach in that circumstance, the immediate right of termination arises. just dealing with the consequences of Providence's interpretation, I won't try not to repeat what I've just said. I make a number of points. First, that it dramatically elevates the status of such a breach above the position at common law. And we would expect that right to be clearly expressed, particularly given the consequences.
Well, so it does on your case. The difference between your case is if you pay on day 27, then the right doesn't arise. But if you pay on day 29, then it is second strike and you're out.
I won't repeat what I've said, my lord. The distinction between the two cases is that on my case, a right of termination has already arisen.
I understand that, but you're now on a submission that it dramatically elevates the termination right as something dramatically different from the common law remedies. But the difference between you is a difference of 2 days in relation to first payment. That's not a very significant difference.
Well, my lord, on Providence's interpretation, one has an immediate right of termination if there is a minor breach, a minor default in the first instance.
Yes.
The service of a specified notice, a minor breach, it being rectified quickly, and it being repeated again at some point during the duration of the contract. I'll come to the vexatious and unreasonable point in a moment.
Yeah.
Now, in our submission, that does elevate that circumstance significantly beyond the position at common law, and one would expect to see that expressed clearly. Now,
what's the
on our
authority for that?
I'm sorry,
What's the authority for that? I mean, as I say, it's now a long time ago, but I was constantly asked, do too late payments justify termination at common law? And my advice was always, it may well do.
Well,
so what's the authority that this elevates it drastically over the common law?
Well, typically, late payment of and in itself doesn't justify without more.
As I say, what's the authority?
Well, I don't have the authority.
Okay, well, it's a bit of a difficult submission to make without authority, if I may say so. I think I'm not sure. From speaking for myself, I accept it. It may well do. It will turn on the facts. That I agree. But simply to say that it elevates it because there could be two breaches, I'm not sure is right. It would depend on the facts, I think.
Well, it would depend on the facts. I mean, if there were repeated breaches or a significant breach which indicated an inability or unwillingness to comply with the employer's contractual obligations, I would accept that would give rise to a repudiatory breach of contract. In circumstances where there were minor defaults, it would be more difficult, in my submission, to advance a case on repudiatory breach, because it would be more difficult to infer from that an inability or unwillingness on the part of the employer to comply with its contractual obligations.
Assume that to be right. I'm not saying it is, but assume that to be right. This is a clause which provides termination rights in circumstances which are additional to any common law rights and must therefore be intended to apply when there is no common law right to terminate. And conversely, it has less beneficial consequences than a common law termination, because the measure of recovery under 8.12 is not the full damages for loss of bargain. So that the contractor who uses this termination provision is in a less advantageous position. But in any event, it's an alternative, and is one of the purposes of this clause to provide certainty, so that whereas there's a good deal of scope for debate about how many payments, how late, how often, etc., are repudiatory, what this is intended to achieve is, if it has the sufficient clarity, that everybody knows that this is where you are, and if you're within it, you can terminate. Is that part of the purpose of the clause?
I would accept that the purpose of the clause is to create a contractual right of termination where a common law right might not arise. I accept that.
And to provide certainty where the common law right might be set about by uncertainty.
I'll come on to the question of certainty in a moment because it links into the question of whether or not the termination can be challenged on the basis of it being unreasonable and vexatious, which introduces in our submission a scope for considerable dispute as to whether or not the termination is valid or not. But we don't put our case as high as it being surprising that the parties would enter into such a provision. Parties are free to enter into whatever provision they want. Our point on this is that given in our submission it elevates the breach significantly beyond the position at common law, you would expect it to be clearly provided for, clearly set out. And in our submission it's not. There's two other points on the surprising consequences of Providence's interpretation before we move on to Providence's reliance on clause 8.2 as the solution. First is that it creates a sword of Damocles hanging over the head of the employer, who may only have been guilty of an initial modest default, rectified swiftly and within the time permitted. In our submission, that is a surprise, absent clear words, that is a surprising provision for the parties to have agreed. Second, the right to suspend for more than one instance of late payment.
Sorry to keep holding you up, but is that the effect of 8.4, so far as the contractor is concerned, that there is a sort of Damocles on the alternative?
On the alternative.
Construction.
On the alternative, yeah. That goes to the asymmetry point, looking at other provisions of the contract, which makes it more understandable as to why the employer would have a more powerful right than the contractor.
If the employer is committed to minor and quickly remedied breaches of the health and safety requirements in the regulations.
It goes back to
It doesn't seem to me that it's any more justifiable to have a sword of Damocles there than it is in the circumstances we're considering.
Well, it goes to my asymmetry point in looking at the different package of. I accept that there's an overlap.
Yeah. All right. I held you up. You're going to your third point.
The right to suspend for more than one instance of late payment becomes more difficult than a right to terminate. Yet the consequences of suspension are typically less severe. And my learned friend says, well, that's just a function of that anomaly. Is a function of the Housing Grants Act, and specifically Section 112 of the Housing Grants Act, which requires notice to be given before any right of suspension is exercised, irrespective of there being repeated defaults. In my submission, that supports our position rather than undermines it, because it rather underlines the point, looking at commerciality, that Parliament considered it necessary before a right of suspension was exercised, in any case, to provide the employer with a right of a period within which it could remedy the default, notwithstanding
One late payment.
on late payment.
We're talking about more than one.
We're
talking about repetition.
Yes, but my lord, on any instance, however many repetitions there were of late payment, the employer would be entitled to notice before the contractor exercises the right of suspension.
Yes, but they're not comparable, because suspension is one-off, potentially one-off for late payment. Here we're talking about at least two late payments.
I'm sorry, Mona. The position on
So the fact that it may be cumbersome to suspend, that's all to do with suspension because of one late payment. We're talking about termination because of a repeated late payment.
Yes,
which is a different beast.
My point on suspension is that it has less serious consequences, suspension typically, than termination. Yet the contract provides, for, on my learned friend's interpretation, for an immediate right of termination upon successive default.
Yeah.
Where, if one wasn't exercising a right of termination, but nevertheless exercising a right of suspension, in each case of default that gave rise to a right of suspension, the employer would be entitled to notice, would be entitled to a period within which he could rectify the default.
Yeah.
Whether it had been...
So speaking for myself, I think that's against you. Because if termination is a nuclear option, then once you've defaulted once, then, as Judge Toolman put it, you're skating on thin ice.
Judge Toolman put it on the basis of the 1998 form.
Well, I follow that, but that always was the position. The clause may have changed, that's your submission, but that was always the position.
My point in contrasting suspension with termination and the provisions that deal with them is to simply underline the point that in this contract, on my learned friend's construction, it is more difficult for the contractor to suspend for late payment than it is to terminate a late payment in the event of successive default.
Yeah, well, you made that submission.
And that's the point I make. Can I turn, my lords, to Providence's reliance on clause 8.2 as the 8.2 as the solution to, in our submission, the surprising commercial consequences of its interpretation.
So 8.2.
The unreasonable vexatious.
We don't need.
Well, do we need to hear you on that? I mean, that's always so fact specific.
Well, that rather is my point. If I could make two short points.
Put it this way, it's got nothing to do, I think, speaking for myself, with the 23 words that we are taking all day to come up
with. Well, my lord,
so you make them in outline, but the case is not going to turn on it.
I was proposing to deal with them very shortly, just to pick up on a couple of points my learned friend made, because he did address you on 8.2 in some detail. In our submission, it's of critical importance that the parties must be able to decide to terminate with sufficient certainty that compliance with the termination mechanism will result in a valid termination. And uncertainty as to contractual rights is inherently unattractive, not least because it creates a landscape for dispute. And the fundamental point is this. Termination for a subsequent instance of late payment, where an earlier right of termination had not arisen, in other words, my learned friend's interpretation, is more likely to be open to question than if an earlier breach had not been rectified and a right of termination had arisen but not been exercised. And the fact that that instance is more likely to be open to question provides a broader scope for dispute as to the validity of termination. And the fact that the courts have provided guidance on the meaning of what is unreasonable or vexatious in our submission does not address or alleviate that fact or consequence. And to take my Lord's point, we agree that it is fact sensitive in each case, although the test is an objective one. It's quite clear from Rhinewood itself that a number of the guidelines are fact sensitive. One looks at whether it is an ordinary unreasonable contractor would have acted in the same way. And the fact that a contractor may have regard to his own commercial interests means, in our submission, that it does not follow inexorably that a repeated late payment would be unreasonable. To take my Lord's point, it is unlikely, in the absence of particularly rare factual circumstances, that termination would be considered to be vexatious. So the question is whether or not it is unreasonable, and the scope for dispute on my learned friend's interpretation is greater than on ours. Because on our interpretation, a right is already accrued, and the contractor and the employer is being indulged by the contractor. So it is less likely to be unreasonable in those circumstances than where there's been no prior right that's accrued, the default has been remedied, and at some point during the contract there is a subsequent default and termination is effective. In our submission, that is more likely to give rise to the question of reasonableness and dispute. But given that the contractor can have regard to its own commercial interest, it doesn't, as I say, it doesn't follow inexorably that such an instance would be considered to be unreasonable. My Lord, in contrast, the commercial logic of our interpretation, I've set it out in paragraph 4.8 of our skeleton. I won't take you through it there now. I've already made my principal points in relation to that. There's greater justification, as I say, for terminating in the event that the employer has been indulged. Can I move to the archaeology of the 2016 form?
Yeah.
I'll start with a legal proposition, which my own friend has in fact taken you to, that derives from Lord Justice Morbick's judgment in procedural management, which is that an exercise in the archaeology of earlier forms is of doubtful legitimacy and is to be discouraged, unless exceptionally it may be appropriate to treat the history and the development of the standard form as part of the commercial background known or assumed to be known to the parties. I don't think I need to take you to Seadrill again, but just for your note, that proposition is set out at page 172, paragraphs D to J of Lord Justice Morbick's judgment. And a similar note of caution and discouragement is found in the Polestar case, which again my learned friend has taken you to, which, if your note, is at page 190 of the authorities bundle, paragraph J. I won't take you to it now.
I didn't hear that. 119.
Sorry, my lord. Tab 15. It's page 190 J.
Thank you.
In this case, Providence says that it relies on the earlier forms principally to rebut the argument that its interpretation is uncommercial, given that earlier versions of the form expressly permitted termination where a prior right of termination had not arisen. Firstly, as to that doesn't meet Hexagon point that absent clear words, the result advocated by Providence is a surprising one. And as I say, we're not saying the parties could never have agreed such a provision, just that such a provision would be expected to be found with clear words. Now, in applying the principle set out in Seadrill, in our submission in this case, there is no evidence that the parties applied their minds or even had knowledge of the earlier forms. In any event, and this is my second point, it is not Providence's case that there was a change in the meaning of the form to address any change in law or other event. To the contrary, it is Providence's case that there is in fact no change in the meaning of the forms at all. And therefore we submit that an exercise in the archaeology of the forms is not legitimate and should be avoided. Without prejudice to that, I make the following submissions on the forms. For the reasons I'm going to develop, my lords, our primary submission that an exercise in archaeology raises, in fact, in this case, more questions than it answers, but if anything, is more supportive of Hexagon's interpretation of clause 8.9.4 than of Providence's. Turning to the 1998 form, which is at tab 3 of the supplemental bundle. I make three points in relation to the form. First, under the 1998 form, the contractor and the employer termination provisions in cases of a repeated specified default are materially the same and contain materially the same wording. The contractor termination provision, clause 8.9.4 equivalent, is clause 28.2.4 on page 7, and the employer termination provision equivalent, clause 8.4.3, is at clause 27.2.3 at page 5b. The second point I make is that the conditions necessary to give rise to the right to issue a notice of termination under clause 28.2.4 are expressed as alternatives by the use of the word or.
Yep.
And therefore, and this is my third point, the ending of a specified default under 28.2.4 is expressed as an alternative ground to the ground that a contractor does not give the further notice. And therefore the words does not give the further notice as used in the 1998 form do not include circumstances where the specified default has ended and the contractor cannot have given the notice, because that is addressed by the first ground, the ending of the specified default. So in our submission, the 1998 form, in its use of the words does not give the further notice, the meaning of those words in the 1998 form is more consistent with Hexagon's interpretation of the equivalent clause in the 2016 form than Providence's interpretation of those words. Moving, my lords, to the 2000...
So your point is that because of the use of the word or, the issue that arises here didn't arise under 28.2.4.
It was made expressly... Well, I think I go further than that.
But
words...
before you go further than that, as a base camp,
yes,
that's right. Because here, if the employer ends the specified default or defaults and the employer repeats whether previously, then you can terminate. And you don't get into the does not give, because that's an alternative that doesn't arise on this basis.
Exactly.
Yeah.
And therefore you say the words as used here mean what you say they mean, clearly mean what you say they mean in 8.9 of the subsequent version.
Right.
Because they are plainly only addressing themselves to the circumstances in which you could give a 28.2.3 notice.
Exactly. And so the draftsman in the 1998 form used those words in the way we say that the words ought to be construed in the 2016 form. Moving to the 2005
So that's
form,
a change. I mean, it's a change on this basis.
Yeah.
Because before you could do it for either reason, now you, on your interpretation, you say, no, you can't look at the words.
I accept it's a change.
Yeah. That's fine. Right.
Just moving to the 2005 form, supplemental bundle, tab 4 at page 12.
Yeah.
Some submissions on this form to pick up on some of my friend's submissions. It's described by Providence as an exercise in abbreviation of the 1998 form. And I've made this point already. If that was so, given that the two clauses mirrored each other in the 1998 form, you would expect the draftsperson to make the same abbreviations to both clauses, and that's not what occurs. I've already made my submissions on that. And no explanation is offered as to why the draftsperson didn't make the same simplification or abbreviation. Moving to the guidance notes, which my learned friend...
And can I just ask, because I haven't really focused on the 2005 form, is that in similar form to what we've now got?
Yes. The 2005 form is in similar form to the materially, for our purposes, to the 2011 form and the 2016 form.
Yeah, fine. Okay.
Now, my learned friend relies upon the guidance note to the 2005 form to support his submission that the intention of the draftsperson was to abbreviate rather than to change the meaning of. Just dealing with the JCT guidance note, it has no contractual status. I make the same point in relation to the guidance note as I do in relation to the prior form, and adopt the reasoning in procedural management. I don't say that it's completely irrelevant. In my submission, the question really goes to the weight and or the assistance that the court should derive from it. What my learned friend relies upon in relation to the 2005 guidance note is he relies on two things. The first is that it doesn't say that the purpose of the 2005 form was to change the meaning of the termination provisions under the 1998 form. So he invites the court to draw an inference from the silence of the author of the guidance note that the intention was not to change the form. And in our respectful submission, that is an optimistic submission. The second point he makes, where he derives the point he makes about abbreviation, is essentially from a sentence of the guidance note, which under structure rather than content, it refers to abbreviation.
Yeah.
But although Providence addresses you on the guidance note for the earlier forms, which it did not do below, it ignores the guidance note for the 2016 form, which is the relevant guidance note in our submission, which it did rely upon below. Now, the learned judge considered that guidance note did not really assist, and that considerable caution should be taken when considering the guidance note. And we with our respectful submission is that we have some sympathy with the judge in relation to that, and clearly the court should approach the guidance note with considerable caution given its lack of contractual status. But in our submission, the guidance note, the relevant guidance note, is the 2016 guidance note, and is notable for being more consistent with Hexagon's interpretation than Providence's. And that guidance note, if I can ask you to turn to it in the supplemental bundle, at tab 6, page 232. It's paragraph 150 that we rely upon, which is at page 232. Now, what I'm going to submit...
232?
232, my lord. Paragraph 150 of the guidance note. what I'm going to submit to your Lordship is that the wording of the 2005 guidance note does not contain this wording. So the authors changed the guidance in relation to repeated default termination provisions. And I'm going to submit to your Lordship that the language used is more consistent with Hexagon's interpretation of clause 8.9.4 than Providence's. For two reasons. Taking the, starting with the second sentence, if it is not remedied within 14 days of that notice, this is the 8.9.3 notice, there is a 21-day period for giving a notice of termination, where after a notice of default, a notice of termination is not given within the 21-day period, but the default is repeated. The party not in default again becomes entitled to give notice of termination within a reasonable time. So it presupposes that a notice of termination has not been given within the 21-day period. Notice of termination, in other words, presupposes that a notice of termination could have been given under 8.9.3 but is not given within the permitted 21-day period, but the default is repeated, and it envisages that the party not in default again becomes entitled to give a notice of termination. Now, on Providence's case, the use of the word again is inaccurate in circumstances where no prior right of termination need have arisen. So in our submission, it is of some significance that the 2005 guidance note has been changed such that the wording in the 2016 guidance note is more consistent with our interpretation. But before moving away from the guidance note, I make one point.
I don't think anything's going to turn on it, but you can read that two ways as well, can't you? Again becomes entitled to give a notice of termination. So in everybody's case, there was an entitlement. Question whether it was triggered.
Well, under Providence's case, no no entitlement to serve a termination notice under 8.9.3 need have arisen.
Well, let's see how you put that. Okay, so you say that now the last bit of 150, in contrast to the notes under the 2005 form, is more consistent with your case.
Oh, yes. Before moving away from the guidance note, I'll just make one point on the fact that it is of note in our submission that the JCT 2024 suite of contracts was published in April of this year.
Yes. So now you want us to decide
Lord,
a form of contract that hasn't even come into existence.
Some 5 months after the decision of the judge below.
Yeah.
In circumstances where, on Providence's case, the judge below has misinterpreted the intentions of the JCT committee.
Yeah.
And there is no change to the termination provisions in the 2024.
And what's the time gap?
5 months.
And the JCT moves relatively slowly its wonders to perform.
Well, my Lord,
I take the point.
You'll be unsurprised to know that the case below got quite significant amounts of publicity.
Yeah.
So it wouldn't have been lost on the JCT committee.
Yeah.
In our submission. And again, just to complete the picture, the 2024 guidance note, and these aren't, I apologise, these aren't in the bundle, but I'll no doubt be corrected if I'm wrong, has not changed materially from the 2016 guidance note.
The one you took us to at 232.
My Lord, yes.
Okay.
Can I deal briefly with the two cases relied upon by my learned friend under the 1998 form, Rhinewood and Brown and Ferreira Key. I can deal with these.
Yeah, well, you'll have to be relatively quick now because we'll need to give Mr. Channels time to reply.
I accept that entirely, madam.
Yeah. So the two cases, Rainwood and
Brown. It's tab 2, page 18 of the authorities book.
Yeah.
I just make 3 points in relation to that in summary. The first, which is obviously common ground, is that it's the decision under a contract incorporating the 1998 form.
Yeah.
Therefore, materially different to the 2016 form in the contract. Second, the decision did not even concern the correct interpretation of the equivalent to clause 8.9.4 under the 1998 form. To the extent that the judge made reference to the equivalent clause in the 8.9, the equivalent clause to 8.9.4, his comments were obiter. And there's also a curiosity, and possibly even, if I've read it correctly, an error in his, I may say so respectfully, in his judgment, in his comments on the clause 28.2.4.
paragraph.
If I can ask you to look at paragraph, he deals with it at paragraph 40, page 31. My little friend took you to this paragraph. He's talking about giving a notice of determination under clause 28.2.4, which is the equivalent of 8.9.4. And giving a notice of determination under clause 28.2.4, the contractor, in my judgment, is entitled to have regard to his own commercial interests. It should be remembered that under clause 28.2.4, a notice of determination may only be served if the employer has either repeated a breach of contract about which he has previously received a warning under 28.2.1, and I agree with that, or where the notice of determination has been given under clause 28.2.3, continued the breach for 14 days after being warned of the breach. Why I say there may be an error in that paragraph with respect to the judge is because he's talking about clause 28.2.4 and alternative rights under that clause by use of the word either. Alternative rights of termination. The question of termination under clause 28.2.3. Termination has been effected under 28.2.3. No question arises as to termination under 28.2.4. In any event, my last point on Rhinewood is that the judge was simply reciting in that clause, in that paragraph, that a repeated breach would give rise to a right of termination under 28.2.4, which is correct on any view. The question is whether a right of termination must also have arisen under 28.2.3 on the old form. So that point was not even considered under the 1998 form. The case of Ferreira Key, as my Lord Justice Coulson indicated, it was an application for an interim injunction.
Yeah.
It's right to say that the court made observations as to the scheme of the 1998 form of contract and the importance of payment being made in accordance with the payment provisions, but that was in the context of the question it was answering in that case, which was whether a notice would be vexatious or unreasonable and therefore ought to be injuncted. So in our submission, that case is of no assistance in construing 8.9.4 under the 2016 form.
Yeah.
My Lord, those are the submissions I want to make on those two cases.
And would this be right,
I'm sorry.
then, that in relation to termination for non-payment under JCT forms, the combined efforts of counsel and their solicitors have identified these two cases. In other words, it's not a. It doesn't appear to be a topic that has, for whatever reason, troubled the courts.
My Lord, so far as our researchers are concerned.
Yeah. Is that because these disputes all go to arbitration? So if there is a big dispute about termination, that'll be in arbitration, not court?
My Lord, it would be me speculating, but that's why.
Yeah, well, I'm effectively asking you to, because it's. I mean, it seems slightly strange, given that it used to be absolute bread and butter work, that there's so little in recent times, and that was the answer that I came up with.
Well, that's one explanation. I suspect my learned friend and I would have a mirror image, make the mirror image submission. I say.
I'm sure you both say it's also clear you've never needed to trouble the courts, but you'll forgive me for taking a slightly jaundiced view of that point. So let's stick to arbitration as the explanation, shall we? Okay, yeah, thank you. So those are the two cases.
I was just going to invite my learned junior just to address you very quickly on the third-party commentary on the JCT forms, if I may.
Oh yes, thank you very much. Yes, Mr. Cameron.
My Lord, may relieve you to hear that I only intend to be 5 to 10 minutes on this short point.
10 minutes at the outside.
Thank you.
Yes.
So Providence in its submissions refers to various commentaries on the forms, primarily on the 2005 form, with one reference to the 2011 form and one to the 2016 form. Those can be found at tabs 10 to 13 of the authorities bylaw.
Yeah.
It's those that I intend to take you through. The references are in particular to the 2005 form because it's that form under which the changes were made to the wording that's now in place. So Hexagon's first point is that it's difficult to see how the briefly expressed views of certain authors as to the clauses within earlier contracts will assist the court, particularly given, first, that the authors may not have specifically considered the point in issue before you today, but even if they had considered it, they will not have heard argument upon it. And thirdly, that there's no reason to suppose that the parties either were or should have been aware of what any of those commentaries, particularly on the earlier forms, had said about the matter. But to the extent that the court would want to take those commentaries into account, it's Hexagon's overarching position that the commentary is something of a mixed bag. Some of it tends to support Hexagon's construction, other parts admittedly tend to favour Providence's. Some of it is simply wrong on either party's case, and much of it is at best ambiguous. So overall, we submit that even if the court wants to place some weight on it, very little weight can be placed on the commentary as a whole because it points in different directions.
Yep.
I'm going to take the court briefly through the relevant extracts, starting with Griffiths on 2005 form. That's at
tab 10.
Tab 10. Thank you. The relevant page is 152, commenting.
Yeah.
On 8.9.4, and it's the wording. If I could ask you to read the whole of the paragraph 8.9.4, and not the subparagraphs.
Yeah.
So the point we make is that the language is more redolent of Hexagon's interpretation than it is of Providence's. In particular, there's a focus on the contractor losing his right of termination under clause 8.9.3, and then that right to terminate being revived. Of course, losing and reviving are particularly important on Hexagon's interpretation, less so on Providence's. In Providence's case, it could terminate even if the right for continuation never arose, such that it neither lost nor revived that right of termination. It's also notable, we say, that the reference to losing the right to terminate if the suspension event ends before 14 days, which is how the provision starts. That's wrong on either party's case, since in those circumstances no right to terminate arises at all, so no question of it being lost enters the equation. We turn then to Lupton. Now,
I don't want to slow you down, but you skipped over Mr Davison's at tab 9.
Yes.
Page 146. I imagine your submission on that is the fact that he expresses the view that the drafting has been improved should lead us to perhaps put less reliance on his judgment when he comes to say that the effect is unchanged.
My Lord, I very gratefully adopt that submission.
Right? Sorry, I couldn't resist that. On to tab 11.
Turning to Lupton, there are two extracts from Lupton. One is on the 2005 form, that's at 11.
Yeah.
There's also an extract on the 2016 form, that's at 13. They're both in materially the same terms, so it may be worth us looking at what's said on the 2016 guidance at page 164. It's really 2/3 of the way down the paragraph at the top of the page. So it's the sentence that I want to start with is if the defaulter event continues for 14 days from receipt of the notice.
Where are you?
Page 164,
Yeah.
Top of the page, 2/3 of the way down.
Yeah.
That
Thank you.
If the defaulter event continues for 14 days from receipt of the notice, the contractor may terminate the employment by further notice up to 21 days from the expiry of the 14 days. So that's presuming that the right has arisen but not been exercised. Then it says, alternatively, if the employer ends the default or the suspension event ceases, and then critically I stress the word and the contractor gives no further notice, then should the employer repeat the default, the contractor may terminate within a reasonable time after such repetition. Now, the use of the phrase, if the employer ends the default, conjunctively with and the contractor gives no further notice, if the specified default had ended before the 14 days, creates an ambiguity. We say it suggests that the author had in mind the ending of the default after the 14 days had elapsed. And on that reading, Lupton is consistent with Hexagon's case and tells against Providence's. That brings us on to Chapel. That's at tab 12. This is the extract with the flowcharts that not only printed the lordships to earlier, that's on page 160. Hexagon accepts that this extract is supportive of Providence's case. In particular, the box in the middle column of the table, no further action. Yeah. But you've got the point, my lord. I make just a couple of observations about this, which is there are errors in it, and therefore that should diminish the weight on which can be put on it. So firstly, you'll note that the box notice of termination by the contractor, 8.9.3, there's an arrow with a no jutting out of that. That on any view should have been a yes. But it is also interesting to note that obviously the giving or not giving of that notice is a binary matter where the contractor could or could not do so. And so really it should be a yes and a no arrow coming out of that. And if the author put together the table properly, the yes would then go down, the no would go down back to the no further action, but the contractor can terminate on repetition. And I simply reflect that if the flowchart had been structured that way, with that further arrow included, it may have prompted some further reflection on the issue that is before the court today. The final point is one may have thought that after the box, no further action, one would expect another box in the middle, giving there's obviously a choice to be made as to whether or not that further notice is given. So one would expect no further action, and then a further box in the middle with another arrow coming out with a yes answer.
Is there a box that says no further action?
The only one is the box at the bottom of the middle row. No further action, but contractor can terminate without notice if default is repeated. So the box on which this particular point turns. Yeah, yes. I'm sorry, I'm with you. Yeah. Okay, understand that. Finally, we turn to Keating, and the extracts relied on at tab 16.
Well, speaking entirely for myself, if this appeal turned on that one sentence at page 197, I think that would be surprising.
My Lord,
I would go further, because I think that sentence was drafted by the judge.
That's precisely the point, my Lord, that I
So for both those reasons, I think you can take it that for once Keating will not be determinative of this dispute.
I will thank you. You've concluded my submissions for me. That's, unless I can be of any further assistance.
No, thank you very much. Yes, thank you very much, Mr. Kaplan. Yes, Mr. Charles, any reply?
My Lord, a pretty short one, if I may. Excuse me. I think we're in the region of 7 points. First of all, an answer to my Lord Justice Stuart-Smith on the interest rights. Can I give some references, please? Within the supplemental...
Would you want to give us the references rather than take us to it?
Sure.
Would that help?
It would, probably. So there are 3 references. The first is to clause 4.9.6. 4.9.6 of the standard form, which you will find in the supplemental bundle, tab 5, page 64.
Thank you.
Which explains that the right to interest arises on the final date for payment until payment is made. So that's the interest period.
Yep.
The rate is the capital R interest rate, which in the standard form is 5% PA above the Bank of England rate. That's at page 44.
44
of the bundle. And that was amended by the parties at page 141 of the bundle, so that you delete 5% and insert 1%, so it's 1%.
And when does it get paid? When does the interest get paid? Does it get paid? You've told us that it flows from the, or interest accrues from the date of final payment.
Yes.
So assume that the employer pays 21 days late. Is his payment meant to include interest for the intervening period?
So,
or is there some wash up at the end?
The way that it's put in the in clause 4.9 at 4.9.7, any such unpaid amount and any interest under 496 shall be recoverable as a debt. I would expect one would apply for that within the next payment cycle, or simply bring a claim for it. So that one word is the interest references. Sorry if I missed out part of what the original question had been. Second point, my Lord, is there's a point that was raised by my Lords in the context of my learned friend's submissions, which is the use of the as opposed to a.
My Lord Justice Popplewell's point. Yeah.
It was, I think, brought up by my Lord Justice Popplewell.
Yeah.
Submissions I make in that regard are, first of all, and my Lords will have this, that if matters were to turn on the distinction between the and a in clause 8.9.4, my submission would be that that distinction doesn't bear the weight to be placed upon it.
But it can contribute.
Well,
We have to interpret the first line, given that the words "for any reason" are clarificatory. So if you take the words out, you then have to look at it and see if it's referring to something that, by implication, could have been. And "the" may contribute to that, even if it's not decisive.
if one was able to say that there are these 4 or 5 things, of which "the" is simply one, then there may be more in the point, but in my submission, there aren't the other 3 or 4 things. And what, in the exchanges with my learned friend, the court was seeking to do is to say, well, if you say that's instinctively the reading of the clause, and if you say that context leads you to the conclusion that you advance, what is it about the context? What are the words that mean that we shouldn't, paraphrasing, give the words their plain, natural dictionary meaning? And the only thing that came up was the use of the word "the." So rather than that being, as I understood it, the straw that breaks the camel's back, or the feather that goes on the scales that tips the balance,
Speaking in
really
terms
the
for
only
myself,
suggestion that
it's
had
not
been
"the."
made.
It's that what is not given under 894 is the further notice referred to in clause 893.
Yes.
And the further notice referred to in clause 893 is a notice which can only be given on in certain circumstances. And that seems to me, at the moment, speaking in terms of myself, to be a basis for an implication that Hexagon's case is to be referred to yours. I'm not saying that that's what I would decide, but it supports Hexagon's case, is my way of thinking. Which is why I picked you up on saying "the," not "a." It's a contributory factor, because it's part of the sentence.
My lord, indeed, sorry, forgive me. When I'm saying the distinction between "the" and "a," it's the use of the word "the" notice as opposed to "a" notice. And then my submission was that is a slender thread on which to hang the case.
Yep.
And my lord says, well, that's one of the contributing factors, to which I say, well, there really aren't very many others.
I thought your submission was going to be it's not a thread at all, because what it means is the type of notice referred to in clause 8.9.3.
Well, my lord.
That's just the same in substance as a clause 8.93 notice. It would mean there was no relevant distinction between a and the. It's just identifying the kind of notice we're talking about.
Well, I do say that as a second submission. As a third submission,
Surprise, surprise. Yes.
one sees the use of the notice as opposed to a notice or a further notice in 8.4.3, where one has the wording whether as a result of the any specified default or otherwise. So in my submission, it makes clear that there really is no difference in meaning. I suspect that insofar as the court took the view that there was any infelicity in the use of the word "the" as opposed to "a," it's probably, as a matter of fact, a hangover from the previous drafting of the JCT form, where there's a reference to the further notice as opposed to a further notice. There we are. So, my lords, that's the second point. The third concerns the submissions that were made about my learned friend's instinctive reaction to the reading of the provision. And the submission, in effect, that when one reads this one instinctively thinks that it means that you have to have had the right to serve the notice under 893. I don't accept that that's the correct instinct to have, but on any view, when one's considering a termination provision, a party seeking to operate or considering operating a termination provision will go beyond their first instincts. They'll read it extremely carefully and consider carefully what the precise words were that were used and what they mean. With something such as this, instinct doesn't take one anywhere. The fourth point, Lords, arises out of an exchange or debate that was being had about the number of yellow cards that might be served. And it is, of course, right to say that it is only when a payment has strayed over the 28-day line on the learned friend's case that then termination can follow. But the point that I make is that if the late payment never gets beyond the 28th day, one would potentially be serving yellow card after yellow card after yellow card in order to potentially even give rise to a right to termination. So one could have a situation in which 15 days in month 1, 16 in month 2, 27 in month 3. But in each case, because it's short of the 27, one has to serve the yellow card, one has to issue the notice of specified default. Otherwise, there'll be no right to termination that could accrue. So one could, in terms of the consequences of the learned friend's construction, have a situation where each and every month or every other month there's a notice of specified default, which is not, in my submission, what was intended. The fifth point concerns the judgment below and the proposition that the JCT haven't amended either the form or the guidance in the period between the handing down of that judgment and the publication of the form. And amongst all the many other points that could be made, I'd make this one. I'm not aware that the judgment below has been reported in any of the law reports, and it doesn't appear to have cropped up on Bailey either. It said that it's received widespread publicity, but that was rather news to me. I can't really take that point any further, but one should be careful with the proposition that this
Well, it has a neutral citation number.
Yes, it does.
So it should be on Bailey, but it'll certainly be on the National Archives.
Has there been any academic comment on it, on the decision?
Not of which I'm aware.
Sorry, Mayor.
Has there been any academic comment on the decision of the judge below? There's a good shake of the head going on 2 rows behind you.
Academic content, as far as I'm aware, no.
But it's the sort of thing that at the schmoozing events attended by everybody concerned with construction law, it would have probably not been off everybody's lips, the excitement generated by this case. You know what they're like, that's all people talk about.
Well,
people will have come up to Mr Williamson at a perfectly normal, acceptable drinks party and said, what did you mean by paragraph 20? If his experience is anything like mine.
No, indeed, Mark. If the case had been widely published, if it had been reported or it had appeared on Bailey, inevitably, people have been talking about it. The fact that it doesn't appear to have been, and I haven't seen any reference to it anywhere beyond, I think there's an article in a.
Well, the winning chambers probably gave a seminar on it, and therefore think it's an extremely important case.
Yes.
So you were saying there's an article, what?
I believe there was. Can I take instructions to be accurate?
Of course.
The publication called Inside Housing, which I mean, I have some niche interests, but that's not one of them. There's an article in Inside Housing that mentions the case.
Peter Apps.
I beg your pardon, my lord?
Inside.
Inside Housing. Is that the blog of Peter Apps, is he called? Inside Housing, who wrote the brilliant book about the Grenfell disaster that I would commend to everybody. I think it is.
I don't know.
There's a lot going on.
Yeah, okay. Anyway, Inside Housing. Thank you.
sure Mr App isn't at the back of the court.
Sixth point, my lords, the Rainwood and Brown case.
Yeah.
That was a case in which, on the facts, there was a notice of specified default in respect of an under payment that was cured before the cure period and therefore before the right to terminate the continued specified default. There was then months later, 6 months later, a further specified default which founded the termination. And so the whole case proceeded on the basis that the form operates, in which, and that's the way that it proceeded up and down the court system. When twice, I think, to the Court of Appeal and once to the House of Lords. There's no doubt about how the form is treated in all the authorities there. And the final point, my lord, is just to respond to my lord's invitation to speculation about why there aren't more cases about JCT terminations. And for my part, for what it's worth, it's probably not much. I suspect it's got more to do with adjudication than arbitration, given that in my experience I do a lot of international arbitration, but very, very little domestic arbitration. And
I suppose that's fair, it's adjudication really. Although termination, repudiation is a bit more, I know you can have those disputes in adjudication, but they're more likely to lead to a further dispute thereafter.
One might think
but that could be arbitration, yeah.
I mean, there is another, the case, we didn't put it in the bundle because the proposition was not controversial, but the Blackpool and File Bus case, which people, I think, got interested in because of what it said about concurrent delay, was a JCT termination dispute. It's referred to in the skeletons, but
nothing to do with.
It doesn't help on this case, otherwise we would refer to it. Unless I can assist the court further. Those are my submissions.
No, thank you very much. Yes, well, thank you to all three of you and to all those sitting behind you who knew that 23 words would take till 4:10, but it has done. We will reserve our judgments, which means that you will get them in due course. Since term ends tomorrow, I'm afraid I can guarantee you won't get them by the end of term, but when you will get them, I can't make any promises. You'll get them in draft. As you know, that's then an opportunity for you to check our typographical and grammatical errors, but it's not a reason to re-argue the case. When you get the draft, it will only be to those whose email addresses we have been provided with, and it's not to be given to anybody else, and you're both very aware, I know, of the penalties for giving the draft to others, because it is a draft. When you have responded in relation to the typos and what have you, at the same time we invite you to agree the order. If you can't agree the order, we will accept very short submissions on any points that remain between you, and we'll deal with those in writing. The hand down will be electronic, so there will be no need for anybody to attend. Thank you all very much.
All right, people.